when a last will and testament fails to name one of the two children of the decedent, is that sufficient as a challenge to testamentary capacity and undue influence? To find out, you have to read Matter of Timer, but it's 4 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where normally I cover New York Court of Appeals cases and try to do it in 5 minutes or less. But this is part of a special limited series I'm doing on cases relevant to the elder law and estate planning community. This is the case of Matter of Timer. This is a case out of the New York Appellate Division 3rd Department. The citation for this case is 2023 New York Slip Opinion 05565, published by that court on November 2nd of 2023. The issue in this case is whether a will that fails to name the children of the decedent is sufficient to demonstrate a lack of testamentary capacity and undue influence that could void the probate of that will. To appreciate what's going on in this case and the context, you have to just understand briefly the concepts of testamentary capacity and undue influence. Testamentary capacity is the concept that a decedent, a person who is ultimately going to have the will probated, has to have a concept, an understanding of the consequences of a will, know the nature and extent of his or her property, and know the people that are the natural objects of his or her bounty. Those 3 things make up testamentary capacity. There are certain elements such as the proponent of the will has the burden of demonstrating that the decedent understood the consequences of executing a will, all those elements of testamentary capacity. And the important part for testamentary capacity is that it only matters at the exact moment the will is executed. That moment of lucidity would be sufficient to demonstrate testamentary capacity, even if 98% of the time the person lacked testamentary capacity. The only question is, did they have it at the moment the will was done? And the last thing you have to know about testamentary capacity is that there's a presumption of testamentary capacity when an attorney drafts the will and supervises its execution. So that's testamentary capacity. The other issue that you have to know a little bit about is undue influence. Undue influence is a concept that there's a moral coercion that means that the will is not actually the product of the will, of the intent of the decedent, of the proponent of the person who drafted the will. It's actually somebody else's will, somebody else's intent that's being cast in the document that's being called a will. The elements of undue influence are motive and opportunity, and the actual exercise of that undue influence in the particular case. And it cannot be just speculative or mere conclusory allegations. A claim of undue influence has to be accompanied by and proven by specific dates, times, and places that would show the undue influence. And the influence must be so pervasive that the will was actually that of the person whose undue influence was exercised, not the decedent / person who drafted the will. Okay, so what are the facts in this case? The facts are, this case is about someone named John Timer. That's the person who died here. John Timer had 2 daughters, 2 biological daughters. And in one of his earlier wills, he left everything to his 2 daughters in equal shares, half to one daughter, half to daughter A and half to daughter B. He ultimately got divorced from his wife and had a new fiance. And that's the point at which he executed a new last will and testament. And in this new last will and testament, he made his fiance the executor of his estate and the residuary beneficiary. The rest of his estate would go to his fiance. His entire estate would go to his fiance if she survived him, and if she didn't, it would go to the decedent's nephew. In the will, he named one daughter and said he specifically disinherited her in the will and said, I'm not giving it to daughter B for reasons that she knows. And he never even named daughter A in the will. So when he died in August of 2020, the fiance brought the will to surrogate's court for probate. And daughter A, who was never even mentioned in the will, filed objections claiming that her father, the decedent, lacked testamentary capacity at the time of the execution of the will, and that the fiance exercised undue influence. So those are the 2 claims she made in objecting to the probate of the will. The procedural history is that the surrogate's court conducted a hearing under SCAPA, Circuits Court Procedure Act 1404, and dismissed daughter A's objections and ordered the will be admitted to probate. And now we have the daughter A, appealing to the Appellate Division, 3rd Department, and that's where we are in this case. And they deal with both of those issues, testamentary capacity and undue influence, and they say, as to the testamentary capacity, it was prepared by an attorney under the attorney's supervision, who now became a judge. That attorney became a judge, and they say that there was sufficient testimony from that attorney/judge and the paralegal that he appeared to have testamentary capacity to understand what he was doing. And the surrounding circumstances show there was animosity because of this divorce. And in that circumstance, because there's a presumption of testamentary capacity, even though he never even named daughter A in the will, which is unusual, it's not sufficient to rise to the level of actually challenging the testamentary capacity that Mr. Timer had. And as to the undue influence claim, they say it was undisputed that when the will was signed in 2016, the daughter's relationship with Timer was estranged because of the divorce. So while the testimony does show that the fiance actually undermined the relationship between the daughters and the father, that happened, particularly in 2020, that does not raise a genuine issue of fact as to whether undue influence occurred in 2016. So this is sort of a case that talks about how difficult it is to prove testamentary capacity and undue influence, even when one of two daughters is not even mentioned in the will. And there's clearly undisputed evidence in the record that the fiance, the residual beneficiary of the will, was in fact interfering and estranging the daughters from the father. And that's the case of Matter of Timer. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.